If you have ever filled out a federal firearms form and paused on the question, asking whether you are an unlawful user of marijuana or any controlled substance, a Supreme Court ruling that came down on June 18, 2026 changed the legal ground under that question, and almost nobody explained what it actually does and does not cover. The case is called United States versus Hemani, and here is the headline most coverage got wrong. This was not the court striking down the entire federal law banning drug users from owning guns. It was something narrower, more specific, and honestly more important to understand correctly, because getting the scope of this ruling wrong could put you in real legal danger if you assume it protects you when it does not. Before we get into exactly what the court ruled and who it actually protects, if you are a gun owner in a state where marijuana is legal, hit subscribe right now, because this exact question, whether legal marijuana use disqualifies you from owning a firearm under federal law, is going to keep showing up in courtrooms across the country, and I track every ruling the moment it lands. Drop a comment telling me whether you think regular marijuana use in a legal state should disqualify someone from gun ownership at all. I want to hear where you stand. Let's start with some context, because you need to understand how big this category of federal law actually is before you understand why one narrow ruling about one man in Texas matters to so many other people. Federal law lists several categories of people who are barred from owning firearms, commonly called prohibited persons. Convicted felons are one category. People under certain domestic violence restraining orders are another. People adjudicated mentally incompetent by a court are another. And unlawful users of controlled substances are another category entirely, covered by the statute at the center of this case. Because marijuana remains classified as a controlled substance under federal law, regardless of what any individual state has done, this particular category quietly touches an enormous number of otherwise law-abiding Americans living in states where recreational or medical marijuana is completely legal under state law. That mismatch between state legality and federal prohibition has been sitting there for years, mostly unresolved, until a case built around one man's specific facts forced the Supreme Court to actually rule on it. Now let's get into the law itself. 18 United States Code Section 922, subsection G, paragraph 3, makes it a federal crime for anyone who is, in the statute's own words, an unlawful user of or addicted to any controlled substance to possess a firearm. A conviction under this section is a felony, and it can carry a sentence of up to 15 years in federal prison, which tells you this is not a minor regulatory technicality. That question about drug use sits directly on ATF Form 4473, the form every buyer fills out at a licensed dealer before a background check clears a purchase. Lying on that form is a separate federal crime, the same charge that made news a few years back involving a member of a former president's family. In practice, prosecutions under this statute rarely start with someone walking into a gun store. They usually start the way Hemani's case did, an unrelated investigation, a search warrant executed for a completely different reason, and agents finding a firearm and drugs together in the same home. This is not an obscure statute sitting quietly on the books. It touches millions of Americans in states where marijuana is legal under state law, but still federally classified as a controlled substance, and it has been the basis for real felony prosecutions for years. Now, here is the actual case, and the specific facts matter more than most coverage bothered to explain. Ali Daniel Hemani, a dual citizen of the United States and Pakistan, was under FBI investigation for reasons that had nothing to do with guns or drugs at all. When agents executed a search warrant at his home, they found a Glock 9mm handgun, 60 grams of marijuana, and roughly 4.5 grams of cocaine. Hemani admitted to investigators that he was a regular user of marijuana. Based on that admission and the presence of the firearm, prosecutors charged him under Section 922G3, arguing that his status as a regular user alone was enough to make his gun possession a federal crime, regardless of whether he was actually impaired or under the influence at the moment agents found the weapon in his home. His defense team pushed back hard, arguing that under the Supreme Court's 2022 Bruin decision, the government cannot simply assert that a modern gun restriction serves a good purpose. It has to prove the restriction is actually consistent with how firearms were regulated historically, going back to the founding era and the ratification of the 14th Amendment. That argument worked its way through a magistrate judge, a district court, and the Fifth Circuit Court of Appeals, before the government itself asked the Supreme Court to weigh in, setting up the ruling we are talking about today. Here is where the ruling gets specific, and this is the part you actually need to remember. The government tried to justify the modern statute by pointing to historical laws against habitual drunkards, arguing those old laws prove there is a tradition of disarming people who regularly use intoxicating substances. The court rejected that comparison, and it explained exactly why. Historical habitual drunkard laws did not target people simply for drinking regularly. They targeted people who were incapacitated by intoxication, people who were actually impaired at the relevant time. Section 922 G3, as prosecutors used it against Hemani, reached him for being a regular user in general, with no evidence he was impaired or under the influence at the moment he possessed the firearm. The court called that a wholly different target than what history actually supports. The government did not stop there either. It also raised a separate justification, arguing that regular drug users as a class present an unusual danger that justifies disarming them regardless of impairment at any specific moment. The court was skeptical of that argument too, noting that the government had not actually proven a connection between Hemani's own conduct and any demonstrated dangerousness, rather than simply asserting the category itself was dangerous. On both of the government's justifications, the historical analogy and the dangerousness argument, the court found the evidence lacking. And it held that courts have a duty to say, when a regulation crosses into unconstitutional territory, no less in the Second Amendment context than anywhere else. The vote was 9-0. Every justice agreed Hemani's prosecution could not stand, even though several wrote separate opinions explaining their own reasoning for getting there. This is the single most important detail in the entire ruling, so listen closely, because getting this wrong could genuinely hurt you. The court ruled the law unconstitutional only as applied to Hemani, based on his specific facts, not on its face for every person the statute might ever reach. That is a critical legal distinction, and it is exactly the kind of distinction that gets flattened into a misleading headline. A facial ruling would have struck the law down entirely, for everyone, in every circumstance, meaning the statute would simply cease to exist as written. An as-applied ruling is much narrower. It means the statute itself is still fully on the books, still a real federal felony, and it can still be used to prosecute someone if the government can show something more than mere regular use, like actual evidence the person was impaired, under the influence, or demonstrably dangerous at the relevant time. If you use marijuana regularly, even legally under your own state's law, and you also own a firearm, this ruling does not hand you blanket immunity from federal prosecution. What it means is that prosecutors now face a much harder evidentiary burden if they want to bring a case like Hemani's, but the underlying federal statute remains real, and depending on your specific facts, you may still be well within its reach. Let's walk through two contrasting scenarios so this distinction actually lands. Picture a person in a state where marijuana is fully legal, who uses it occasionally in the evenings, keeps a firearm secured in a home safe, and has never been found in possession of the two together, has no other criminal history, and has never been observed impaired in public. If federal agents encountered that person during an unrelated matter, Hemani gives that person's lawyer a genuinely strong argument, because the facts mirror Hemani's own case closely: regular use, no demonstrated impairment at the relevant moment, no separate dangerousness evidence. Now picture a second person who is stopped by police, found visibly intoxicated with a firearm on their person, and has prior arrests connected to violent conduct. That second scenario looks nothing like Hemani, and prosecutors would have a far easier time distinguishing it, arguing that actual impairment and demonstrated risk were present, which is exactly the kind of evidence the court said the government lacked in Hemani's own case. The lesson here is that this ruling protects a very specific factual profile, not a blanket category of people. So what should you actually do with this information? First, understand that federal law still classifies marijuana as a controlled substance regardless of your state's law, and Form 4473 still asks the question directly. Nothing about Hemani changes what that form asks, or what happens if you answer it dishonestly. Second, know that after Hemani, prosecutors likely need to show something closer to actual impairment or demonstrated dangerousness, not just that you use a substance regularly, if they want a prosecution like this to survive a Second Amendment challenge going forward. Third, and this matters most, do not treat this ruling as legal cover to lie on a federal form. The false statement charge is a completely separate crime from the possession charge, carrying its own penalties, and Hemani's case does not touch that issue at all. Fourth, if you hold a state medical marijuana card, understand that the card itself can become evidence of regular use in a federal case, so the existence of state-level legal protection does not translate automatically into federal safety. If you have specific questions about your own situation, whether you are a legal medical user, a recreational user in a legal state, or someone with a mixed history, this is exactly the kind of case where a conversation with a firearms attorney in your own state is worth having, because the fine details of your circumstances are what will actually determine whether Hemani's reasoning protects you or not. Now let's talk about what comes next, because Hemani is not going to be the last word on this statute, and it is not going to be the last case testing the historical analogy requirement against a federal prohibited person category. Watch for the Department of Justice to quietly change how it builds these cases going forward, likely adding evidence of contemporaneous impairment, public intoxication incidents, or documented erratic behavior connected to drug use, rather than relying on an admission of regular use standing alone the way prosecutors did against Hemani. Watch also for defense attorneys around the country to start citing Hemani immediately in pending prosecutions under this same statute, arguing that their client's facts mirror his closely enough to warrant dismissal. And keep an eye on other federal prohibited person categories, because the same historical analogy scrutiny the court applied here is already being tested against other parts of federal gun law, including restrictions tied to nonviolent felony convictions and age-based restrictions on handgun purchases. Hemani is one data point in a much larger pattern of the court demanding real historical proof rather than accepting loose comparisons, and that pattern is going to keep reshaping federal prosecutions for years. Zoom out for a second. This is not a ruling about whether drug users generally have a right to own guns. It is a ruling about how carefully the government has to tailor a historical justification to the actual conduct it is punishing, and the court held prosecutors to that standard unanimously, all 9 justices, even the ones who disagree about how the underlying historical test should work at all. That kind of agreement on the outcome, even with disagreement on the reasoning, tells you the government's argument here was genuinely weak. If this cleared up what Hemani actually does, narrow, as applied, evidence-based, rather than the blanket legalization some headlines implied, hit that like button so more people get the accurate version. Subscribe, because as applied challenges like this one are going to keep working their way through federal courts, state by state, and I will break down every ruling as it happens. Comment below if you or someone you know has run into this exact question at a gun counter, because you are far from alone.